Hello, thank you everyone for joining us. We're just going to wait another couple of minutes to allow more participants to join in. Thank you. Hello and welcome everyone to our webinar From Conflict to Claims. My name is Samira Amari and I'm the Head of Business Development and Marketing at Afridi and Angel. Thank you all for joining us today. In this webinar, we will be focusing on some of the key areas most impacted by the recent conflicts in the region, including contractual risk, force majeure, employment, ongoing transactions, and related claims. Our panel today includes partners Charles Loback, Shatura Randenia, and Abdus Samad, who will be sharing their insights and practical perspectives on these issues. We will begin with a brief overview of the key topics and then move into a Q&A session. Thank you to those of you who have submitted questions in advance. We will do our best to address as many as possible during this webinar. The webinar is scheduled to run for 1 hour. If needed, we will extend slightly, but aim to conclude by no later than 5:15 in consideration of everyone's time. Please do continue to submit your questions throughout the webinar using the Q&A function on Zoom. If we are unable to get to all questions, we will be happy to follow up with you offline. With that, I will hand over to Shatura, who will start us off with an overview of force majeure and hardship. Over to you, Shatura.
Thank you, Samara. Good afternoon, everybody. I'm glad you could join us, and I'm hoping you're all keeping safe and well. When we looked, as you would have seen when we sent around the invitation for this webinar, we got a lot of questions on force majeure and hardship. So we thought it might be a good idea to start off with that. I don't intend to go too deep into what the law says on this, but what I'd like to do is give you a fairly broad, but hopefully sufficiently detailed overview as to what force majeure is and what hardship clauses are. Because I'm sure you would have seen, this is one of the first words that are sort of being floated around when something like this happens. If you recall, this was also a topic of conversation in 2020 when the COVID pandemic broke out. And it was also the case in 2008 when the most recent financial crisis came up. So let's refresh ourselves a little bit. The important thing that we need to understand is that just because there is a conflict going on, it does not automatically mean that force majeure provisions are triggered and you have that protection. So it's an investigation as to what is the best approach and what is the relief that we can get using these principles. Can move on to the next slide. Thank you. So force majeure is literally means a superior force. Now, there is an important distinction between UAE law and English law. And that is this. In English law, force majeure is a creature of contract. In other words, if your contract does not have a force majeure provision, then you cannot rely on it. Now, English law has other concepts such as frustration that assists parties. But the advantage of being in a civil law system is that force majeure is a codified principle. So even if your contract does not contain a force majeure clause, you can still rely on the statutory provision to give you that relief. Now, you may all wonder what would be the case if your contract already has a clause, and we'll get to that later. What you need to bear in mind is that not every disruption, not every unforeseen event, not every war or conflict is necessarily satisfy the requirements of force majeure. The key under UAE law is that it must make performance impossible. Now, that is perhaps the most important thing that you can take away. It has to be impossible. It can't be more difficult. It can't be more onerous. If it's only more difficult, more onerous, more expensive, it does not qualify as force majeure. You have to actually show impossibility. And there's a reason why that matters, because under UAE law, you also get relief when it is not quite impossible, but it makes it significantly more difficult to perform a contractual obligation. So the first step is we need to understand what the applicable law is, what is the obligation that is affected, and whether the event, in this case, the conflict, makes performance impossible or merely more difficult. So an example of something being impossible would be if you have oil cargo stuck inside the Gulf, which can't get out. Now, that might satisfy impossibility. The fact that your cost of procurement has gone up further because of the increase in oil prices, which has been caused by the conflict, would not be force majeure. Can we move on, please? Right. So what you'll see on your screen, which I won't necessarily take you through, is what the law says, or the UAE Civil Code says on what force majeure constitutes. Performance must be rendered impossible by a supervening event, which could not have been foreseen. And the effect of that is that your corresponding obligation ceases and the contract is automatically cancelled or rescinded. Now, partial or temporary impossibility may also occur, right? And in those cases, the creditor, the party that is owed the obligation, has the option to cancel, provided the other party is made aware. Now, very importantly, what you are going to see on screen today on what the Civil Code says is going to change when the 1st of June rolls around. And I'll get to that earlier, but this is later. But this is what the law says as now. Now, the other remedy that you have is under Article 49. So it has to be an exceptional event of a general nature. So it can't be just private to any person that could have been foreseen and makes performance so onerous as to threaten grave loss. So that's the standard, not impossibility, but this is what essentially a hardship clause. It makes it more difficult. And what the court can do under the present legal framework is to adjust the contract. The court steps in and says, this is now far too difficult for the parties to perform, so we are going to now change the terms. All right? So that is the two key provisions in civil code that will be relevant in this context. Next slide, please. So again, I ran through the previous instances where these principles came into play. So the approach of the UAE courts is not to say take a blanket approach to any of these cases. Every time an event of force majeure is pleaded, they will take it on a case-by-case basis, right? And you have to remember that in the UAE, in any event, there is no system of binding precedent. I'm talking about the onshore system here. The DIFC courts are slightly different. The DIFC courts and ADGM courts are different. So on each matter, you'll have to convince the court if you want to get the benefit of a force majeure clause or the hardship clause, you will have to satisfy the court on the facts of each of the requirements that we just spelled out. But as a general rule, the strict application of the law is the norm. The courts will scrutinize the facts very carefully before they find that there is a cancellation of the contract due to force majeure, or before they intervene and they change the contract, because both of them are seen as fairly exceptional remedies. If we can move on. So what is the relief that you can get? All very good to show that there's a force majeure or the performance of your obligations have become far more onerous. So under 273, which is the force majeure provision, the principal relief is the cancellation of the contract. Now, under the current law, only the affected party when it comes to force majeure, I said there's also temporary or partial impossibility. In those cases, under the current law, only the creditor can ask the court to grant relief, to cancel the contract. But under the new law, both parties can do that. And if there is a temporary impossibility, under the current law, the remedy is the contract is rescinded. Now, what does rescinded mean? It means that the parties are put back to their previous position, which itself can give you, it doesn't mean that you walk away scot-free. There are certain obligations that you may have to incur in order to make the parties restored to their previous position. But something that will happen as of 1st June is that where there's temporary impossibility, the court can also now come in and modify the terms and not just rescind the contract as a whole. There's the reduction of obligations that we spoke about, that is in Article 249. That is where there's a hardship, not force majeure. Now, under the current law, the court can reduce the obligations or amend the obligations. But under the new law, which will come into force in June, the court also has the option to rescind the contract. So the court will have more power at that point. So you get released from your contractual obligations, and especially in the context of mukawala contracts, where you have been done partial performance, or you have completed partial performance, you will be entitled to payment for whatever you have performed until it is the court deems that the force majeure event occurred. Can we move on? So what happens if your contract has a force majeure provision, right? Now, under UAE law, we discussed that this is a feature of the civil code. Now, if you have a contract in place, the court will first look at the contract, because under the UAE commercial code, sorry, there's a old reference to the commercial code there, but under the new commercial code, the first place that the court will look at when it comes to commercial contracts is what is in the contract. And that will prevail. And it is only if you go through the other waterfall of provisions that you see there, which is commercial custom or previous practice, and it is only at the last resort that they will apply the civil code. So the contract will take primacy. But what is important is that you can even have a clause that says force majeure will not apply in XYZ circumstances, and that is a legal that is legally permissible. However, you can't contract out of the hardship clause, which is 249. So if there's a clause that says that, no matter what happens, the courts will not have the power to step in and adjust the contract to make it a little bit more equitable, that provision will not be upheld. And if you do have a notice, if you do have a force majeure requirement, and this is something that people get tripped up on a lot, is that usually these clauses have detailed notice provisions. There's usually a prescribed form with which to give notice, and then there's also a timeline. There will be often clauses that says if an event of force majeure has occurred, a party must give notice within X number of days. And if they do not give notice within X number of days, then they may no longer rely on force majeure. Next slide, please. So we now come to the present circumstances, right? Like I said, just the fact that there is a conflict going on does not necessarily mean that there is force majeure. Your performance or your ability to perform or your counterparty's ability to perform could be caused directly by the conflict or the hostilities themselves, or it could be taken by certain preventative measures that the governments or the region has taken. So we need to look very carefully at the facts and see where the best position that you can take is. In most cases, we find that it is easier to take refuge under Article 249 rather than argue force majeure, because impossibility is usually an extremely high standard. And oddly enough, in the rescission of a contract, you may actually end up being worse off because you have to restore the contracting party to the previous position or pay damages. If the court comes in and adjusts the obligation, so for example, to say, okay, well, the price of this can be increased by 5% in order to compensate for the market changes, or to say, well, we will give an extension of time to compensate or to make performance possible, that actually might be a better outcome for parties who want to seek a relief. The next slide, please. Yeah. So what do you need to do? Review your contract is the first thing. Figure out what your governing law is. If there's a force majeure provision, advise yourselves as to whether force majeure actually applies, and if so, make sure you comply with the notice provisions. Take a close, hard look at whether it makes performance impossible or whether it just makes it more difficult. And very importantly, and this is something that people tend to forget in the pressure of the situation, is to keep records. Make sure that everything is documented. The UAE courts in particular are very document reliant. So all steps that you have taken to mitigate your losses, there is a duty to mitigate losses under in the UAE. Those should be documented. If you receive notices from your subcontractors or suppliers which will have a bearing on your performance, then you should keep those ready, because you never know when these documents will be needed to do it. We don't usually find parties running into court now. Obviously, there are parties will try to work with each other and get over this period, but you usually go to court, 6-7 months down the line, or maybe a year down the line, sometimes even more, after things have settled and people want to try and balance the books. So it's very important to keep these contemporaneous records. And I think that brings me to the end.
Yeah, thank you, Chat. Thank you, Chat, for this. Charles, you're up next to talk about employment issues.
Certainly. Okay, thanks, everybody. Thanks for your attendance, by the way. Thank you, Chatura, for your remarks. If no one else has questions for you, Chatura, I might have a few. But can we go to I've only got one slide, folks. It's because the number of employment issues that have been that have arisen so far that we've been asked about is relatively limited in number. That might, of course, change if this situation continues. We are in the 5th week right now. If it goes on 5 more weeks or even months, who knows how long it's going to last or not, then other issues might come up simply because of the duration of it. But for right now, it doesn't seem to be creating all that many concrete issues, except the ones you really maybe would expect, the need to work from home, the need to work remotely, and so forth. This contrasts quite, to me, dramatically with the COVID crisis. Because if you were here in the UAE or another country that was affected by COVID, you might remember, well, UAE in particular, UAE handled this really well because there were guidelines issued. The cabinet declared it formally to be an economic emergency situation. The Ministry of Human Resources and Amortization, which handles employment matters in UAE, gave all kinds of guidance to employers about what they could do with their workforce. Again, the problem in COVID, the problem now, was that many of us, our biggest overhead, the biggest single item, is payroll. And what do you do when you've got to meet payroll every month, but your revenues go from here to here? It's a real problem, and it's not by any means trivial. During COVID, the Ministry of Human Resources and Amortization gave guidance on what you could do to move your workforce to remote working, temporary, part-time working. You could put people on furloughs. You could have reduced compensation. And there were guidances as to how to go about doing all this, fairly detailed guidance. And by and large, during COVID, this succeeded. A lot of businesses who might have failed otherwise did not fail and continued to operate after COVID was over. But mind you, that lasted for, we're in the 5th week now of these military operations. COVID lasted a year and a half. So it was quite a longer duration crisis than the one we're going through right now. But what I want you to sort of focus on is that you don't really have the option right now to tell everyone, okay, half salary for all of you, or okay, you're all going to be working half time because we can't afford to pay you. No, the only accommodation you really have right now is one that was baked into the labor law, the new labor law, when it was enacted at the beginning of end of 2021, taking effect in 2022, which is remote working. There's now accommodation for that in the labor law. And, I think a lot of employers have gone to that. Indeed, it's been perhaps almost mandatory if you're going to discharge your obligation as an employer to maintain a safe workplace. So when things are especially dicey, you give employees the option to work from home or work remotely. I think all of us are used to that nowadays. Our servers are robust enough to handle many personnel working from home. If you're in a professional services company like we are, clients, you don't have meetings in the office anymore with clients. You have everything is done electronically like this. So at least for the time being, working from home is the way to address the situation, and it seems to be the way to keep on working in the midst of all this uncertainty. If you really have to go beyond that, you're going to have to look more closely at the traditional methods of reducing your workforce overhead and payroll overhead, things like with the consent of the affected employees, putting them on reduced hours or reduced compensation, maybe terminating some people, but it means the old way of termination with notice, with end of service gratuity and all that stuff. But I don't know. We haven't gotten questions so far about termination of services. We've really gotten questions about, can we put our employees on work from home or work remotely? Is it okay? And basically, the labor law now allows that, and people are using that technique, at least right now, to keep the workplace open, to keep business going in and dealing with the situation as we face it. So that's really, I guess, all I've really got to say about this. It's again important for all of us as employers to one of our obligations is to maintain a safe workplace. So if you're having your people come to the office or come to the workplace, make sure you have like first aid kits on hand, that everyone knows where to go when there's an alarm and you've got to get away from windows. Maybe you even want an evacuation plan or something like that if you've got to leave the building quickly. So think about stuff like that. There's no legal mandate to do those things, but there is a legal mandate to maintain a safe workplace. So think about the kinds of measures you should take to make sure your employees can continue to come to work safely or work remotely safely. And that's kind of, I guess, where things stand right now. It might be very different in 5 weeks' time. Maybe this will all be over by then and we'll be all kind of smiling and laughing at how nervous we were, or it might still be, like it is now. So it's we have to wait and see and keep in mind, all of us who are employers and all of us in the case of our firm who advise employers, you've got to look out for everybody, look out for your entire workforce, make sure they're all able to keep on functioning, and stay safe. And that's kind of all I have by way of prepared remarks on employment matters. I'd like to hand over, and of course, if you have questions later on or in the Q&A, we'll get to those once my colleague Abdus Samad shares a few of his insights with you. Abdus Samad, I'm going to turn over to you now, so take it from here. Thank you.
Sorry, I was muted. Thank you, Charles. Thank you, Chatura. Hi, everyone. Thank you once again for joining us. I am going to take a slightly different subject, which is, my colleagues have spoken about commitments that you may have already entered into in the employment sphere in terms of your commercial contracts or transactions. Obviously, business at whatever pace has been continuing since the start of this conflict, globally and in the UAE. There will inevitably be transactions, contracts, arrangements that are being negotiated, considered, discussed as we speak. And so the question arises in the middle of all this uncertainty, where do these ongoing matters stand and how do you navigate that uncertainty in terms of your dealings? Could we move to the next slide, please? So and like Charles, I don't have extensive slides, so this is meant to serve more as food for thought than anything else. One of the important facets of a transaction or M&A is, of course, the due diligence that you look at before entering into a contract, and so due diligence, in my view, and in my ongoing experience, has taken on heightened importance because you could potentially be evaluating an acquisition or an investment while the market conditions are fluctuating week on week, day on day. So the question arises, for example, if you're looking to buy a company or invest in one, and this target has certain revenue streams, well, to my colleague Chatura's analysis, we now need to ascertain if there's been a potential force majeure claim, or if there's a risk that this will arise in relation to a potential to a contract or an arrangement going forward. And your due diligence needs to be targeted and more nuanced to specifically catch and evaluate that risk. But equally importantly, while you are preparing, you also need to make sure you have some sort of deal certainty, both as a potential buyer and a potential seller. And so, how do you ensure that the deal you're devoting resource to in these times of uncertainty is going to go ahead, or if you find that the deal is in fact closing? Now, what we've seen, and there's obviously highly context-specific issues that arise from deal to deal. But what we've seen is that buyers, sellers, and investors are trying to narrow as much as possible the gap between signing or committing and closing a transaction, to make sure that what they're signing up to is as much as possible, as much as feasible, what they end up getting. Now, of course, How much you can minimize that gap is as I said, highly context driven. But that's what we're seeing in terms of the approach of the people that we're working with. The other issue is we've noticed that there is now a larger gap between expectations of buyers and sellers. And my view is that's simply because sellers have not yet adjusted their expectations because there's still a hope or a desire that there will be some sort of short to medium term return to whatever the new normal is going to look like post-conflict. There's also a desire to ensure that they don't leave value on the table because of an emotional response to this conflict that we're in. Buyers, of course, and investors are wanting to avoid paying a premium for something that is no longer worth what it would have been 5 weeks ago. So that disconnect is going to, what we're seeing is that disconnect is being structured through more complicated consideration arrangements. So how you pay for something you are buying or what you receive in relation to something you are selling is going to get drawn out and is going to become more nuanced. So instead of fairly simple small deals, consideration arrangements, we're seeing longer and more complicated earnouts with more complicated conditions attached to it. So buyers want to make sure that the business they're pricing in March or April 2026 is going to perform within those parameters, say 3 months from now or even a month from now. And so more of the payment arrangements are being pushed back as much as possible and linked to actual ongoing business performance than evaluation as of a certain date. And frankly, I think that's been a trend we've been seeing for a while, even pre-conflict. But I think that it's become more important and a more difficult negotiating point in the last 5 weeks. The other sort of word I'd say, in addition to force majeure, the one that we hear more frequently now than before is material adverse change. So it used to be that a lot of sellers, again, to have deal certainty, used to push back on a material adverse change condition in acquisition contracts. It's become a harder position to maintain for a seller because of the way the markets are moving and because of the way business disruption is expected to fluctuate in the short and medium term. So we're seeing a harder push by buyers to make sure that they are covered as much as possible in any gap between sign and close, to make sure the business they are looking to buy is not going to become a substantially different type of business, a less valuable one, in a few weeks' time. That's all I have to say by way of sort of transaction management. What I will say more generally is that in terms of M&A, in terms of negotiations of contracts, what we're seeing is more time to sign and to close rather than buyers and sellers pulling out of negotiations. So what we're seeing is not a drop yet in the pipeline. We are seeing deals take longer to close and being more heavily negotiated. Again, because of this aversion to risk and the uncertainty that has come about everything we're going through. And for what it's worth, that's been our experience so far. I'll pause there. I think we're going to move to Q&A next.
Thank you, Abdus Samad. So a few questions have come in, and since you just Samad, I'm just gonna read this out to you since you just finished talking about it, and you did allude to it in a way. Have you seen a drop in M&A volume?
Thank you, Samaran. Very interesting question. Again, I've said we haven't seen a substantial drop in our pipeline. What is happening is that there is hesitance and negotiations are stretched out longer. Due diligence is taking more time. What I will also say is that it's highly dependent on industry and the dynamics of the business that is being bought and sold. Some businesses are going to thrive in the middle of the conflict. Some businesses will see inevitably a very drastic drop in revenue and or profitability. Some businesses will be quick to bounce back, and some businesses will take longer. And of course, we yet don't know how long or how intense this disruption is going to be. So this is all speculation for the time being. What I will also say is that we're often part of a bigger picture here in the UAE. So transactions that are taking place across continents and over 13 jurisdictions, for example, very rare that they will pause or be suspended because of the regional disruption. A lot of these deals, which are very substantial in value and size, take place because of more strategic reasons or more, more than just a look to add inorganic growth or incremental revenue. So it's very rare. I won't say it's impossible, but it's very rare that will really be driven by regional market disruption. So a lot of the work that we have is actually, again, part of a bigger picture that hasn't yet been affected by what we're experiencing in the region. But again, time will tell whether we will see a more pronounced drop in transaction volume or whether it'll just be the case that transactions will sort of hum along for the time being until everyone has more clarity. I have not yet, if I'm honest, seen a deal being pulled on that had already that was ongoing or about to launch.
Sorry, I was on mute. Just to continue with you, Samad, before we move on to other questions, how do you address concerns stemming from market uncertainty in deal documentation?
So there's two ways of. Maybe I'll take a step back. What I advise against is rushing into signing a deal that you have commercial concerns on. It's the advice that I've given recently is that it's better to pause than to try and structure an exit based on commercial convenience, and this links up to force majeure. What I will avoid is trying to structure a deal that is easy to get out of. I would prefer that people I'm advising or we are advising are more cautious about what they are signing up to in the anticipation this disruption will become something we have to live with in the short to medium term. What that looks like is anyone's guess. And so with that in mind, the two approaches that can help mitigate risk is, as I said earlier, trying to bridge or eliminate, if possible, the gap between signing and closing a transaction. Not always possible, but where it is, that's one effective way of making sure you don't have an issue after signing that you don't like. The other way is of course to have more clearly defined parameters on what should trigger either party's ability to walk away. Now that goes back to the concept I discussed about the material adverse change. the clearer you are in your negotiations and your drafting about when fundamentally the nature of the thing you bought or sold has changed, and when either side should be able to walk away, the clearer you are, the more certainty you have, and the more confident you are going into the deal. Now, again, this means not having to rely on force majeure or frustration or something that is really to be considered a last resort approach when nothing else is feasible, if that's possible at all. So clarity and clarity up front is what I would say is important.
Thank you, Samad. Thank you for that. Shatura, I'm gonna come to, so I'm gonna read out a question to you. Can you elaborate on the enforceability of cancellation penalties for client contracts and the obligation of minimum guarantees with a partner contract?
The answer to that is very simple. I suppose it depends on the contract. When it comes to cancellation penalties, I think something that you need to also bear in mind is that as far as UAE law is concerned, the courts always retain the power to adjust any penalty, any pre-agreed amount of damages to reflect the actual loss suffered by the parties. Now, that's a double-edged sword. The number can go up as well as it goes down. But I suppose in putting that question into the present context, I think there are two things that could happen. One is if there's an impairment of performance, which could expose you to any of these pre-agreed damages. One of the things that you can do is that under UAE law, events of force majeure can also act as a reason to disrupt what we call causation. So there's a wrongful act and there's damages suffered by it. Under UAE law, you can take the position that whatever damages that you suffered was not because of me, because I was unable to perform because of an extraneous factor. So therefore, I should not be held liable. So there are several arguments that you can take if you are threatened with claims for damages, or if you're facing a cancellation for non-performance or otherwise. But really, it does go back down to the contract and what it says. A contract is ultimately an instrument of risk allocation. So you look at the contract to see, did the contract foresee this kind of, or envisage this kind of circumstances? And if so, where did it allocate risk? And if it did not allocate risk, then you go to the legal principles to see how that risk can be allocated and what relief the parties can get stemming from.
Sort of, I guess you could, in the same token, I see this question. The second question is connected to the one that you just covered. Can you give a contractor a material cost escalation in the current situation? For example, the contract is EPC FIDIC contract.
Okay, so obviously we are in a part of the world where standard contracts are used, but parties are very how should I say, they very readily amend those standard terms to have particular terms to apply to those parties. Under the standard terms, I don't think that kind of position is possible because it's usually a fixed amount. But there are certain things that you can do. The first is obviously you can try and negotiate the clause. The other one is that if you can show that this would cause you a hardship, it would make performance far more onerous. Under Article 249 now, after June, Article 224, to say that the change in circumstances such, it was caused by events that were unforeseen, that are not of a public nature, which I had no control over. And now because of this, I am having a really difficult time now. There also, you have to remember that just because you may suffer a loss, the court will not step in and try and change those clauses. You have to show that performance under the contractual terms. If you're held to that standard, it will be ruinous, that it would threaten you with, essentially being rendered insolvent or bankrupt. So that's how high that standard is. But generally, you will find in most contracts, there is some wriggle room. Usually, there is a clause that does put the market risk on one or the other of the parties. So you need to go to the contract, but there are arguments that you can take to say, it could maybe perhaps be the subject of a variation order or something along those lines. So you'll have to look again. Always the starting point is the contract, and then you will invoke the legal remedies that you can.
I think you covered this in your presentation, Chatura, but just stepping back a bit. If the contract is silent on force majeure, how do you deal with it?
You go straight to the civil court, assuming that this is governed under UAE law. The fact that a UAE governed law contract does not have a force majeure clause is not fatal. You can still rely on what the law says to say that I'm still entitled to seek the relief of force majeure. What actually is a little bit more complicated sometimes is where you have a force majeure contract that's a clause that already in your contract, because it can do one of two things. It can make the application of force majeure more narrow, or it can make it more broad. Now, if you're on the receiving end, then obviously, and you have a broad force majeure clause, then that's to your benefit. You can say, well, obviously, war is included in this. Now, there's also a question of whether we are at war or not. There's definitely a conflict. So it again depends on how that clause is framed. I've seen many force majeure contract clauses that refer to war, and within parentheses it says whether declared or not. So if you have a clause like that, then it's an easier proposition to rely on it and say, look, this is clearly within what is contemplated on the contract. Because ideally, we don't want to be running to court. We want to put a strong position to our contracting counterpart to say, well, this is why we think that we should be given relief, and then take it from there.
Okay, thank you. Now, I know we've been talking about UAE laws, but one of the questions is, does the same force majeure concept apply across other GCC countries? Is this something you can comment on? And if an agreement does not include an express force majeure clause, which is what you just covered, does the force majeure concept still apply by operation of law in those jurisdictions other than the UAE?
I would think so. All the civil codes of the GCC region are drawn from the same place, which is the Egyptian Civil Code. So I would be surprised if there's any civil code in the GCC that doesn't have it, but perhaps Charles would know better because he's been around here longer.
No, I was going to say what you said, but I'm not sure about Saudi Arabia, because they don't have the same civil code approach to the to law that the rest of almost all of the Arab world has, except for Sudan. I mean, Saudi Arabia traditionally has based their statutes, their laws on Islamic Sharia, and I do not know if there is a force majeure concept embedded in Saudi law. I'd have to check with Saudi council on that. But yeah, Kuwait, Qatar, Bahrain, Oman, for that matter, Lebanon, Jordan, Egypt, of course. Yeah, I think even Iraq. the concept is there. And so if you have a contract governed by Kuwaiti law, and it does not have a force majeure clause, you do what Chatura said. Go to the Civil Code of Kuwait and see what the force majeure requirements are in that statute.
Okay, thank you. I wanted to, before I move on to, there are a couple of questions under employment, but just since we're talking about force majeure, would you consider the closure of the Strait of Hormuz a force majeure or a hardship? How would you classify it?
It depends on the obligation that you have to perform. If your obligation is to carry a piece of cargo through the Strait of Hormuz right now, then I would argue that that amounts to impossibility, and therefore would qualify as an event of force majeure. If your obligation is to sell a cargo in a different country, say in some Asian country of that same cargo, or you're supposed to sell, 1,000 barrels of oil, what you will have to do is, unless it's specified to be a particular consignment of a particular tanker, you can buy it from somewhere else and still perform your contractual obligation, in which case it is not force majeure. It would be it would make it more onerous. It would make it more expensive. Now, whether it will entitle you to go approach the court and say, please give me relief, that depends on how much of an effect it is likely to have on you.
That's interesting to say, because that means that you could have say if the Qatari oil company declares force majeure because it can't supply LNG to Korea and Japan, that sounds legitimate, because you really cannot get a tanker through the straits. But if it's an oil trader based in Singapore or whatever, says, I will sell you Persian Gulf gas at this price for the next 5 years, they're out of luck. They can't invoke force majeure because they haven't actually, if they hadn't specified Persian Gulf gas, maybe they'd be, anyway, but you see what I mean? Gas of a certain quality, they'd be unable to appeal to force majeure because they can get gas from other sources, at least theoretically. Would that make sense? I mean, so you have
that's
even but different look at the facts. Underlying facts are what really makes the difference.
No, that's bang on, actually. And that's the same example I was referring to, because I had this conversation with an oil trader friend of mine 2 days ago.
Yeah,
so he's having this exact same problem.
Yeah.
Yeah.
But if it's just a case of like shipping, building supplies, metals and cement and sand and things like that you need to build a building or perform a project, if those are more expensive, we've been through this before during COVID, during the 2008 financial crisis. Those are not force majeure events.
Yeah. So, but actually, Charles, you make a very good point, and perhaps it goes back to the first question that Samar asked of me. So, for example, there's two things that will happen. One is that prices will go up, and the second one is that there might not be availability in the market for certain products, especially if the global supply routes are being disrupted. So there, you may not be able to get relief if unless your contract says otherwise, that the prices went up, so therefore I should get a corresponding increase in price. But what you can probably get is relief from penalties for delay, because the contract may not always say. Contracts usually will say that, okay, if there's a price change in the market, then that's the contractor's responsibility, or the employer's, as the case may be. But very often it won't say about availability. So you can always go and say, well, there's a problem with availability. That's not my problem. That is not provided for in the contract. That is somebody else's risk. And therefore, I should be given at least an extension of time. Now, whether you get a corresponding monetary entitlement with that extension of time, because obviously the longer you take to do something, the more expensive it is. That's the subject of a different analysis.
Okay, well, thank you very much. Thank you very much for this discussion. Charles, you covered pretty much what was introduced, permissible under COVID when it comes to employment reductions, terminations, all that sort of thing. But I mean, again, this is a scenario of if a company has experienced a drastic reduction in revenue, and as you mentioned, the single largest overhead expense is payroll. While this situation lasts, assuming it lasts a bit longer, what can we do? Like somebody was asking, can we place our workforce on half-time? Can we cut salaries by 50%? Can we terminate? Yeah.
Yeah, well, you can't do it unilaterally. If you want to put your workforce on reduced compensation or reduced hours, or like unpaid leave or whatever, you need to get each employee's consent to that. You couldn't do it unilaterally. You couldn't impose it on them. So it's again, right now it's early days, I suppose, and maybe things will change if this continues, but right now, the only real option you've got, again, is just to let the employees who wish to work from home, or maybe if you think everyone should work from home, work remotely, do that. I guess there's one thing to bear in mind. If you're having employees that are working from outside the country, just bear in mind the 6 months absence can lead to the residence visa being canceled. I think there might be some accommodations being considered given this current circumstances, but don't let that calendarize residence visa renewals for your workforce if employees want to work outside the country, and if you're going to let them do that. But yeah, otherwise, right now there aren't a lot of options available. You've got to kind of you don't have the option of missing payroll. Okay, I'm quite sure that if you miss payroll, it'll be a red flag on the WPS, and the ministry will have a word with you. And you don't want to get downgraded or sanctioned or whatever by the authorities. So it's at the moment, I guess we all just hope that the current disruption does not last much longer, and that we can return to normal workplace functioning as quickly as possible. But yeah, it would be. I guess right now, don't make it worse than it has to be. Okay, don't go off and miss payroll. Don't go off and fire employees unilaterally. Don't go off and take unilateral measures when it just might make a bad situation worse. Does that help?
Yeah, that's fun. No, that helps a lot. Now,
there's another question. One more question here about lease payments, and it might affect a lot of you if you're like us and work from a leased office. And I just signed a whole bunch of rent checks back in January, and now I feel really stupid. But yeah, I mean, again, is the current situation a defense for your obligation to pay rent for your office or your home? No, I think that's right, Chatura. We're not in force majeure yet. When the office is functioning, you're given access by the employer, by the landlord. I mean, likewise where you live. So even if you make the decision sort of to evacuate, which some embassies have been recommending, bear in mind it doesn't get you off the hook paying your rent at least until the end of your lease. So maybe you can negotiate a termination with the landlord, but it's to be negotiated, not just you don't just bugger out and leave it unless you want to just take the risk of never never seeing that rent money again.
Yeah, and I think it's also relevant to point out that at least as far as the law is concerned, there is no obligation to renegotiate. There is an obligation to perform your contracts in good faith, and after 1st of June to actually negotiate your contracts in good faith. But once obligations are crystallized in the contract, you can't, unless there's no obligation to renegotiate it thereafter. The parties can if they want to, but there's no obligation. And generally, unless the parties agree or a court says otherwise, contractual obligations can't be amended. just to close that up.
Okay. Shatura, or that this is probably to all of you. It's again more on force majeure. How do you claim your rights from consultants, and how do you respond to subcontractors' letters on force majeure? This is more like the how-to. And I think you kind of touched on this, Shatura, earlier in your presentation, but.
So the first thing is to make sure that, first look at process and thereafter look at substance. Usually contracts that contain a force majeure clause would have a mechanism by which to invoke it. There are timelines, there are certain procedural matters like, should it be, obviously it has to be in writing, but sent to whom, sent when, what should it contain, what should it specify. So you need to make sure that all of those requirements are satisfied. And if they are not, you can take the position that, this is not a valid notice. The second one, obviously, is on a substantive level, where you may wish to push back and say, no, we disagree. There's no event of force majeure here, because it does not make your performance impossible. And that, that might be something that you get back if you're the party sending that. So just because a force majeure notice has been issued does not necessarily mean that an event of force majeure has occurred. Ultimately, a court or a tribunal is going to be the arbiter of that. But generally, I would say what what we spoke about when COVID came around. It's a difficult situation for everybody, and people have long institutional memories over here as well. So if there is genuinely a case for hardship, people will remember who was willing to renegotiate terms and do business when things get better, as to opposed to people who were, just looking after their own interests. So there is, again, now it's a little bit, it is uncertain because we don't know how long this will go on for. But, eventually it'll end, hopefully sooner rather than later. So there's always goodwill and social capital to be earned in the matters of contract at any given time.
But you're saying also that even if there's objectively speaking a force majeure situation, or at least a very good argument for one, you've still got to give notice in accordance with the contract. It's got to be within the time limits. If it says within 30 days of the occurrence of a force majeure event, you must give notice. So just emailing your contact person in the prime contractor or in the customer, that's not going to be good enough. It's got to be notice as per the contract, and it's got to be in the time limits set out. And even if there's force majeure in the underlying civil code, you're going to be out of court if you don't do notice in accordance with the contract. Are you saying that?
Yeah, I've seen cases where where a tribunal or a court has looked at the provision and said, well, it was quite simple what you are supposed to do in terms of giving notice, and you have failed to do that. Now, not every contract will tell you what the consequence of failing to give proper notice is, right? There are certain contracts that says unless notice is given within these timelines in a proper manner, it would be invalid. It will not be deemed acceptable. There are others that are silent, and on those types of contracts, I've seen particularly arbitral tribunals trying to find out, well, what was this notice intended to do? Essentially, it is a mechanism to address risk. The reason why you want notice to be provided to you in a certain fashion in a certain period of time is you as the main contractor or the employer or whatever it is your role is, can take the corresponding provisions to mitigate damages and look after your own interests. So then it becomes a more difficult proposition to say, oh, it was invalid notice, so therefore you cannot rely on force majeure. The courts will probably take a more purposive approach to that, to say, well, you knew about it. It couldn't have been a secret. So therefore, let's forget the procedural niceties and let's go down into whether it was actually an event of force majeure or not.
Okay. Can I answer Andrea's question, Sarah? I'm going to answer anyway. Okay.
Sorry, yeah, please go ahead, Charles.
Andrea's asked a question about you've got a blue collar workforce, which I guess that means they aren't going to be able to work remotely, right? You can't dig a ditch remotely or drive a truck remotely, right? But they're on annual leave and they're in their home countries, and there's a lot of them. Can you tell them don't come back, wait until it's safe? This sounds like I'm sure a lot of people out there are facing exactly the situation. Again, you can't do it unilaterally. You can't say, "Oh, you're all fired" or "You're all on prolonged." But try and work it out as a mutually agreed thing that we're going to put you on. We'd like you to go on leave until the situation here is safe enough for you to return. I mean, if you're in Sri Lanka, for example, like some people I know, right? It'd be foolish to come to Dubai. You're safer there, right? So just let them maybe persuade them to agree to take extended leave in a place where it's objectively speaking safer than here. And then the question is, do you call this an extension of annual leave, which is paid leave, or is it going to be unpaid leave for the part where their annual leave is all used up? And that's really for you to figure out as a matter of your own payroll policies. But if I'm thinking of a lot of people I know who are maybe the blue collar type of worker, they'll save up their leave and take 3 years all at once. And maybe these people have timed it pretty well if they took their leave, say, on February 15th and they're still out. But yeah, again, you can't do it unilaterally as the employer, but it is a good chance perhaps to let people go on to formally document it, in writing, that you're on extended annual leave or extended unpaid leave, whatever it might be. And if they really don't have work to do when they come back to Dubai, then probably that's the best way to handle the situation for the time being. But just don't do it unilaterally. That's if you're the employer, try to negotiate the status with each individual employee. And although that's a lot of people to contact when they're not even here, that's the safest way to go, I think.
Thank you, Charles.
Yeah.
Thank you, Charles. I think I just want to end the Q&A with one question that now we keep hearing about the rise in oil prices and shipping costs. Everything is going up. Everything is going to reflect. Now, I guess that's just my view. Everything's going to become more expensive. But one of the questions is, can we adjust prices due to increased shipping costs or any cost for that matter, I suppose? I think you're on mute.
If you've got one of these ongoing fixed price contracts, maybe no, but if you run a grocery store, of course. So it really depends on if you're
subject to government regulations, I think.
Subject to consumer price rules and all that stuff. Yeah. But that's happening already, Samra. I mean, but it depends on if you're locked into a fixed price long-term supply contract, you might have less freedom than if you're just analytically every sale to a customer is a different contract with a different price. So yeah.
I see. Yes.
Does that make sense? I mean, it kind of like a stupid lawyer.
Yeah.
It's a lawyer saying it depends, but that's why it depends, because there are different kinds of contractual obligations, and the impact of these prices is going to be different.
Sounds good. Well, thank you. I think this brings us to the end of the webinar. I thank you everyone for joining us this afternoon. Thank you, Charles. Thank you, Shatura, and thank you, Abdus Samad, for your time. And I just want to share with everyone that yes, a few questions came through about whether we will share the slides. Yes, we will share the slides. There will also be a recording of this webinar. And and if you have any other questions, please feel free to get in touch with us offline. We will be happy to help. And thank you all. Stay safe, and let's hope this situation resolves itself soon. Thank you.
Thank you.